Ms. Blatt, just so I can understand analytically your argument, could you waive immunity in district court, and after the waiver, would they have jurisdiction?
No, under subject matter jurisdiction is not waivable.
Is there another instance in which we have seemingly conflated subject matter jurisdiction and immunity?
I mean, I don't think so. Schooner Exchange is a jurisdictional holding. This court has said in many cases, although the holding goes to jurisdiction, it later got developed in the civil context as absolute immunity until the restrictive immunity developed. But, I mean, the Foreign Sovereign Immunities Act also, on its face, says jurisdiction, they shall be immune from jurisdiction in federal and state courts. So, I mean, we have two independent arguments. The first is just a broad argument saying there's no jurisdiction under 18 U.S.C. 3231 for foreign sovereigns. And if this court rejects that, we have another argument saying, well, the FSIA on its face in Section 1604 would cancel out any criminal jurisdiction that might otherwise exist under Title 18.
I don't see how the difficulty I'm having is understanding how the immunity claim is woven into subject matter jurisdiction.
Sure. Our immunity claim is if there is subject matter jurisdiction and the Foreign Sovereign Immunities Act doesn't apply, we would say there's still a common law immunity because there just never has been a criminal prosecution of a sovereign or its instrumentality anywhere. And the only argument the executive has is that it has the unilateral right to decide if there is criminal immunity. But just like, just foreign sovereign immunity is a well-developed common law ground that courts develop, which is one of the reasons we say that the court has to decide that question.
But normally in an immunity case, you could waive immunity. And so it's rather personal. It could be an affirmative defense, but I don't normally think of it as a part of subject matter jurisdiction.
That's correct. The immunity argument is a tertiary argument. If you've already rejected the argument that there's no jurisdiction, then it's absolutely waivable by sovereign or state or anyone else, the federal government. And yes, so absolutely, immunity is waivable. It's just that if you agreed with us on either the FSIA or, well, the FSIA has its own waiver provision, so the sovereign can always waive under the FSIA.
But aren't you hamstrung there because that's civil?
Well, no, our main argument is that the Section 1604 with bars any jurisdiction speaks more broadly than Section 1330, which opens up only civil jurisdiction. So the actual immunity conferring provision or jurisdictional stripping provision is textually broader. It's not limited to civil cases.
But then you trap yourself with the exception for commercial activity.
Right. So I don't think that's correct, but for the three reasons, text, structure, and purpose. The text is that the only grant of jurisdiction for the exceptions is in 1330. And so remember, the 1330 is part of the FSIA. It's passed in one continuous act. The very first provision of the Foreign Sovereign Immunities Act is Section 1330. And it says there's civil jurisdiction for these exceptions. And then you get to the broad cancellation of all jurisdiction and then the 1605 waiver. The second reason as to structure why I don't think the commercial activities exception could possibly apply in criminal cases is you would think Congress would actually just care about how those cases would proceed, and all of the provisions that go to venue, service, answering the complaint, removal, are all on their face civil only. And so it leaves, it's just inexplicable. And finally, the results that I said are borderline, cataclysmic, that 50 states, all counties in any city in this country that has prosecution authority would all of a sudden have jurisdiction to prosecute any country qua country. And because Congress has expressly waived immunity and canceled it out on the statute, the executive branch can't do anything about it. And so the executive can cry and say this could start a war, and you're stuck with the statement by Congress saying, yeah, but Congress waived immunity for all commercial activity exceptions.